Are you a commercial tenant? Does your lease include access to an alternative power supply? Hi, I'm Simon Dippenaar and I'm an attorney. As our load shedding stages continue to go up and down like hemlines, we are becoming more and more reliant on our generators and inverters to keep our businesses running. If you're a commercial tenant of a unit in a large complex, you may tap into the property's main generator, but what are your rights when it comes to your access to it? If your commercial lease specifically includes or excludes the alternative power supply and specifies the cost of access, or states explicitly that your rent is inclusive of the cost, you can switch off this video now. You are covered. But the situation is rarely that clear-cut, especially if your lease was drawn up before load shedding became a daily occurrence. A recent dispute between a commercial landlord and tenant highlights the grey area that can arise over possession of a non-material thing like power. Now, I'm using material to mean something that can be seen or touched. We can see the effect of power, such as lights or functioning machinery, but we can't actually see the electricity that makes them work. This was at the heart of this particular case. Now, a tenant in a shopping mall relied on the mall's generator for backup power during load shedding. They did not pay extra for the service. Then, without warning, a landlord introduced a diesel recovery levy to be paid monthly. The tenant challenged the levy, saying that they were already covered by the terms of the lease, which described an all-inclusive monthly fee for all expenses related to the lease of the premises. The two could not reach agreement and referred the dispute to arbitration. However, the landlord took matters into their own hands and cut off the tenant's access to the generator. The tenant went to court and secured an urgent reconnection order. It's important to note at this point that the reconnection order was a temporary solution. Now, the arbitration is still pending and will determine whether or not the tenant is liable to pay the levy. However, the court's decision is important because it sets a precedent and defines a principle. It establishes that access to an alternative source of power is protected by the spoliation principle. Now, what is spoliation? Now, spoliation means the wrongful deprivation of another's right of possession. For example, in rental housing, if a landlord changes locks and denies a tenant access to their home or seizes personal property in compensation for unpaid rent, this is illegal and a violation of the tenant's right to the property. The legal term for this is spoliation, and the tenant can seek a spoliation order against the landlord. In the commercial context of the case we are looking at, the court did not consider who has the legal right to the property. This will be decided at arbitration, but the court was interested in whether the possessor was in peaceful and undisturbed possession, and whether they were unlawfully deprived of that possession. Now, with possession of something material like the generator itself, this is straightforward, but access to the power produced by the generator is more complicated. The tenant had to prove quasi-possession of the power supply. This judgment confirmed in principle that access to an alternative power supply falls under the law's protection as much as possession of a material thing. Now, it is up to arbitration to look closely at the wording of the lease and decide whether or not the tenant has an enforceable right to the landlord's alternative power supply, and whether they must pay extra for it. But landlords in this situation cannot unilaterally cut off any existing power supply without following legal process. Now, if your landlord has done this to you, or if you have any questions about a commercial lease agreement, you can contact me on the number below and I'll help you sort it out.